Hello viewers. There is a lot of discussion and interest about the 10th schedule of the Constitution and anti-defection laws, especially in the context of the recent political developments in the state of Maharashtra. So we have invited Mr. PDT Achary, the former Secretary General of the Lok Sabha, to have a detailed discussion on the implications of the recent Supreme Court orders, as well as the larger implications and the larger issues pertaining to anti-defection laws. Mr. Achary is an authority in this field, and he has written extensively on the topic of parliamentary procedure and anti-defection laws. So we are privileged to have Mr. Achary in our show. Welcome, sir.
Thank you.
So, sir, let me start by pointing out a very peculiar situation which has arisen in the Maharashtra case. So, on one hand, on June 27th, the Supreme Court effectively kept in abeyance the disqualification proceedings initiated by the Speaker. And 2 days later, the Supreme Court refused to interfere with the floor test ordered by the governor. So there is an argument that when disqualification proceedings are pending, floor test cannot be held. And also the other argument that both are distinct proceedings and cannot be interlinked. So a natural doubt, which many viewers also asked, was that can there be a floor test when there is a cloud over the eligibility of certain members? How do you see this development, sir?
Actually, it's a very interesting development. Well, there is some merit in the argument that when disqualification petitions are pending, the floor test should not be held. Because the people who may be disqualified will have voted in that floor test. So people who are not eligible to vote will vote in the floor test. So that is one argument which is being put forth. But there is another argument. There is no guarantee that they will be disqualified. After all, they may not be disqualified. In that case, how can they be prevented from voting? So these two arguments are there. The point is, we must look at the context. The government has actually lost its majority. Majority in the sense, it's a perception. After all, it is the governor who has to form an opinion about this particular issue, whether the government has lost majority or not. And then the governor will ask the chief minister to take a floor test and prove his majority. Right. Now, as per the constitutional scheme, as you know, when a ministry loses its majority, the chief minister loses its majority in the house, or if there is a perception about it, that is the opinion the governor forms on this, that he has lost majority because of certain developments which have taken place. So many people have broken away from the party and so on. So the governor has formed an opinion that the government has lost its majority. But of course, as per Bommai's judgment, majority has to be proved on the floor of the house. So the presumption is, till the government loses its majority in the house, it is presumed to have majority. So that is the presumption. But all these things cannot go together. The point is, if the governor forms an opinion, after all, governor is entitled to form an opinion. Of course, he is the person who has to initiate this process. And so he forms an opinion that the ministry has lost its majority and therefore it should take a floor test. So when the governor feels so, then there cannot be any delay in that. Because, as you know, that a government which doesn't have the number, doesn't command a majority in the house, that government cannot aid and advise the governor. It doesn't have that capacity. It loses that capacity to aid and advise the governor. And a government which has lost its majority cannot remain in office for any length of time. It has to go. And another government which commands majority has to come in. Now, this is the constitutional scheme that we have. But of course, there can be an argument that how is the governor so certain that this government will lose majority? So many things can happen. And ultimately, the chief minister may end up getting the majority or proving the majority. That is possible. So that is why it is always safe to depend on the outcome in the House and wait till the outcome, till the House decides. That is it. But this is the way things have happened in this country, in many places. Governor asking the chief minister to do this, take a test and all that. But here, this matter is slightly complex because of the fact that there was this petition against some of the members.
Right.
So it can be argued both ways. That yes, if they are disqualified, naturally disqualified means disqualified with retrospective effect. It is not that disqualification will take effect from the day the speaker decides. It will take it has retrospective effect. You know, in Rajendra Singh Rana's case, the court had very specifically said that when Mayawati's MLA went to the governor along with Mulayam Singh Yadav and others and told the governor that Mayawati's government should be dismissed, the Supreme Court said on that day itself he incurred disqualification, and therefore the disqualification will take effect from that particular day when the disqualification occurs. So that is the decision of the court. So that means it has retrospective effect. That strengthens his argument that the floor test should not be held till the matter is decided by the speaker. I think that is the safest thing to do. But then, on the other side, this constitutional requirement that if a government loses its majority and the governor forms an opinion, after all, governor is the constitutional authority who is entitled to form this opinion. And if he feels that the government has lost its majority, then that government has to take a test.
Right.
These are two things, which are important considerations. But then the way it has happened, the Supreme Court has come in the way. Supreme Court has come in, and Supreme Court has said floor test will take place. But then the most intriguing thing is that the Supreme Court has said that the decision of the House on the floor on the confidence motion will be subject to our decision on this petition.
Right.
Now, this is something. All other things I can forget, but not this particular order, because that goes to the root of the matter. Now, that means you are directly attacking the autonomy of the House and its privileges. Well, after all, there are umpteen judgments of the Supreme Court which emphasized the privileges of the House so far as conducting its proceedings is concerned. A legislature has absolute privilege over its proceedings. What it decides or what it does not decide or what it does inside the House is something which you cannot look into. You can't review that. There is separation of powers, and the judiciary has no business to come into this and say that this decision you take, but we will decide whether that decision should be implemented or not. What kind of an order it is? The Supreme Court, actually, this bench has gone against the well-known decisions of the Supreme Court and the law that has been settled over a long period of time, starting from the MSM Sharma's case in Bihar. So this law stands settled that the legislature has absolute freedom to conduct its proceedings. Legislature has absolute freedom to take whatever decision it wants to take on a particular issue. Nobody can question that. So that is the position. That is why it is baffling actually how the Supreme Court has made this order that the decision of the House will be subject to what we decide on this petition.
In fact, sir, during the hearing itself, the bench had orally remarked that if we ultimately find the floor test to be ordered without authority, we can annul it. The Supreme Court felt that the floor test is a reversible situation, but it's very astounding how realistically it is possible how to reverse a floor test, because there will be political consequences for a floor test. And also,
apart from that,
yes.
There are constitutional issues which arise out of it.
Right.
The House is autonomous. The House has absolute independence to decide what it wants, and no other authority can interfere with that. Cannot say that this is subject to our decision, and we will decide what you should decide, and all that kind of thing.
This reminds me, sir, in 2005, I think, when Mr. Somnath Chatterjee was the Lok Sabha Speaker, when the Supreme Court had issued notice to the Speaker, like Supreme Court did not pass any order, when a mere notice was issued, Mr. Chatterjee had taken up that issue, saying that the Speaker cannot be called into question, and that had blown up into a great constitutional crisis. But now these days, there is no such questioning also. I think
there's no such reaction, in fact, from the constitutional authorities. When another constitutional authority tries to interfere with the functioning of a constitutional body, there is no reaction.
Right. Because even the order saying that, or the order extending the time for giving reply, even that was an interference at the interim stage. And
absolutely, I have already written about it.
Right.
In fact, my article has come in the Hindu today. I have mentioned about it. It is an interference because Supreme Court, that Kihoto Holohan of 1993, it was a constitutional bench, and that bench had very clearly said that no interference by the court, even at the interlocutory stage, on any issue. So that was an absolute decision of the absolute order of the court. And how can a vacation bench of the Supreme Court defy that order?
It seems that the Supreme Court was influenced by the Nabam Rabia decision, because the petitioners, the Shinde group, had raised an argument that when a petition seeking Speaker's removal is pending, the Speaker cannot decide on the disqualification. I think so. That was the argument which pursued at the bench. What do you think, sir?
Actually, there are many things which are wrong there. Actually, in this kind of a formulation, there are things which are wrong. First of all, the Speaker or the Deputy Speaker in this particular case has received a communication, a kind of a email communication. It is supposed to be a resolution for removing the Deputy Speaker. And that was sent from some unauthorized kind of source. And therefore, Deputy Speaker had some doubts about the authenticity of that document. So naturally, when he has doubts, he cannot proceed with that. It's a very serious issue because it is supposed to be a motion seeking the removal of the Speaker. And it is considered to be a very serious issue. And that is why Constitution itself provides for a period of 14 days after the giving of the notice. When the motion is taken up for final disposal, there has to be a gap of 14 days, which is not there in any other case, but only in the Speaker's case, because Speaker is the highest. Speaker is considered to be a very high constitutional authority, and he is the custodian of the rights of the House, and he is an impartial umpire and all that. So nobody should move such a motion just like that, and they should not trifle with this procedure. That is why the rule makes it as tough as possible. But apart from that, coming to the main issue, actually here, the Deputy Speaker has other reasons also, which he did not mention. The point is, a Deputy Speaker I mean, the motion that was sent could not have been sent because the House was not summoned at that point of time. A motion can be given notice of only when the House is summoned, only after the House is summoned. Before that, no member can give any notice. So it was a totally irregular kind of thing. It had no validity at all. This notice had no validity. Thirdly, the Supreme Court has asked a question. How can the Speaker or Deputy Speaker be a judge in his own cause? Now, that question was totally out of place because under the rules, the motion has to pass through the preliminary stage of admission. Any notice that comes to the House needs to be admitted by the Speaker. So this also needs to be admitted by the Speaker. But admission of a notice is done on the basis of certain rules. And the rule stipulates that there has to be a very definite, specific charge against the Deputy Speaker. There has to be a charge and that charge needs to be related to his functioning in the House, his performance in the House, whether he has broken any rules, whether he has done something which has caused irreparable loss to the opposition, things like that. There are so many such cases or so many such situations where this problem can arise. That is all. But you cannot cite a charge which is not related to the functioning, the Speaker's functioning in the House. That is why the Speaker has been given this power to admit or not admit at the threshold. And if the Speaker and the rule itself empowers the Speaker to do that, and then how can this question arise that Speaker is a judge in his own cause? Actually, Speaker doesn't decide the matter on merit. It is the House. So in this case, it is the House that is the judge, not the Speaker. Speaker is doing only a preliminary exercise of admitting the motion. And after the motion goes to the House takes a decision. So that question by the Supreme Court, was totally misplaced. It was not a question which was asked I mean, out of the knowledge of the proceedings and all that. It was a question which was asked because the bench perhaps did not know these niceties or rules. So from that point of view, there is no motion pending against the Speaker. So Speaker is not disabled. Speaker is not disabled to decide this, to reject this. There was no motion pending. Therefore, the Speaker was fully entitled to address that disqualification cases. Yeah.
So the Nabam Rabia situation was not squarely applicable in the instant case because there the motion was pending for the assembly.
There, the Nabam Rabia says if it is pending, if it is pending consideration of the House, then he should not do it. But if it is not pending, then that question doesn't arise at all. So that case doesn't apply here.
So even after the Nabam Rabia decision was rendered in 2016, certain commentators had expressed certain doubts and certain concerns that this principle can be misused by persons who are seeking to defect by simply sending a casual notice to the Speaker. And
Absolutely.
Perhaps the court should have gone into that question. Do you think so?
In fact, this what I feel is that this Nabam Rabia is particularly this matter, because this was not the main issue before the court.
Right.
But even then, they pronounced a kind of a verdict on this. And actually, this needs to be reviewed because the Supreme Court, Justice Kehar, entirely focused his attention on the word the then members. All the then members. That particular word then. He emphasized that word and said that what it means, all the members at that time when the notice is given, and that means all the members who were there in the House at the time of giving notice should be able to participate in the voting. So you cannot disqualify anybody. This was the logic. But it's a very strange kind of logic because in the House, in the Constitution, there are different concepts of majority in the House. Now, Article 100 says that any decision that is taken by the House is taken by a majority of the members present and voting. That is the normal procedure. That is the normal thing. Any decision that is taken by the House is done by a majority of the members present and voting. Then, so far as the Constitution amendment is concerned, there is a special majority. And there is a special mention about that. That is the majority of the total membership of the House plus 2/3 of the members present and voting. These are the two conditions which need to be fulfilled when there is a constitution amendment before the House. Now, so far as the Speaker's thing is concerned, the removal motion of the Speaker is concerned, there it says that all the then members of the House. Now, what does it mean? Or what can it mean? Or what should it mean? All the then members means that the members of the House without the vacancies. I mean, people who are, I mean, the seats which are vacant. Seats which are vacant. Yeah.
You mean, sir, President?
So only the members who are there at that time. But that does not mean that you cannot or should not disqualify members. Whoever is there in the House, I mean, the total membership of the House, suppose some 10 or 20 people have been disqualified. So the total number will be less by 20. They are other than members. That is how it is. Otherwise, first of all, when this particular article was framed by the Constituent Assembly, they had no idea about this anti-defection law and all that kind of thing, you know. So it is absurd to give an interpretation to this on this ground.
Right.
So I think it needs to be reviewed. Otherwise, there is a lot of the mischief potential of this judgment, you know, is very, very great. Anybody can move a no confidence motion just to preempt the Speaker from deciding the disqualification petition.
Right, sir. And so in the beginning, you had mentioned that it is up to the satisfaction of the governor to call for a floor test. And if the governor feels that the government has lost majority, he can definitely call for a floor test, and that has to be immediate. But if the government has lost majority due to acts of defection, then don't you think the question of disqualification might should be given primacy in such a situation? Because the losing of majority can happen due to many reasons. If one partner completely withdraws from a coalition, that can happen. But if there is a kind of a faction which has withdrawn support, and that faction cannot claim the defense of paragraph 4 of the 10th schedule of pertaining to merger, so in that would be a very peculiar situation, I feel. Right.
Yeah, certainly. Here, you know, the governor is only technically correct, but the issue was that is why I said both issues are important. Constitutionally speaking, the governor cannot indefinitely postpone the floor test. Right. He has to do it, and he must swear in another government, you know, in place of the government which has lost majority. At the same time, now, as you rightly said, that the people who defected, after all, people who defected, they will lose their membership. That is the consequence. So when that is the consequence, naturally, one has to take it very seriously when you take such a decision. A constitutional authority should take this decision very with a lot of consideration, with a lot of seriousness, I must say. So certainly, defection, you know, is an issue which has not been taken into account by the governor at all, as if the governor was not aware of it, or he did not bother about it. That is what happened in this case. But then, you know, the Supreme Court said, you come on 11th. We will hear you.
Yes.
And those people have been given time till 12th May, I mean 12th July.
July, yes.
At least 12th July, they will submit the report, the replies. And after that, the speaker, after all, there are 16 people. Speaker has to sit and examine it, each petition, and then he has to, he has to draft a judgment and all that decision, his decision. All that, it will take some time. So the question is whether the speaker, the governor, if he is convinced that the government doesn't have the majority, then can the governor wait till then? That means for almost 2 weeks or 3 weeks, a government which is supposed to have lost its majority will remain in office.
Mm.
These are some of the questions, which do not have a ready answer. That
So
is, if
quite
you,
an unprecedented situation.
that is,
The case is concerned. And
Yeah.
his claim is that he is the real Shiv Sena. He has not left the party, and he has the support of the majority members. But the other side, they are still pressing the disqualification petition. And today they have filed an application before the Supreme Court saying that these members, the Eknath Shinde and other his supporters, they should be suspended from the House till the disqualification is decided. So how do you see this development? What is the way forward now?
no, that plea perhaps is not a very reasonable one. They should be suspended and all that. That is not how it is. After all, members against whom disqualification notices are given, they do attend the House. There is no disability attached to them till the decision is taken by the Speaker. So that plea is not based on any reasonable ground. But the point is that they should give disqualification notices against all these people, because all of them, by their action or by their act, have voluntarily given up the membership of the party. All these people. So all the 39 or 40 or whatever number he has, they have incurred disqualification now. That is just, it's a question of the Speaker deciding it. But now the Maharashtra situation has taken a different turn altogether now. The Deputy Speaker, now they will be electing the Speaker tomorrow on Monday. That is the first thing that they will be doing.
Right.
Once the Speaker is elected, the Deputy Speaker will become powerless. He can't decide anything. All these things will be transferred to the Speaker, because then the Speaker will be deciding this. And the Speaker has a problem, in fact. Now, at the moment, nobody knows which party he belongs to, what party he represents. After all, this Eknath Shinde, he has become the Chief Minister. And he has certain supporters who are all members of the Shiv Sena officially. But Shiv Sena, the party as such, has not authorized him to enter into an agreement or some arrangement, alliance with the BJP and form the government. Party, which is called Shiv Sena, is led by Mr. Uddhav Thackeray. He is the party chief, and without the party chief's consent, or without the consent of the whatever high-powered committee in that party or decision-making authority, just like the working committee or the Congress party, they may also be having some such body. So without their support, how can a party member, a member of the legislature wing of the party, go and enter into an alliance with another party and become a chief minister? It's a very tricky kind of situation. He has not been allowed by them. It is that party which has to take a decision about this, not the legislative wing or any member of the legislative wing. Legislative party is just a wing of the original political party. So all decisions are taken by the original political party. And legislative party is not recognized or is not registered by the Election Commission. Mm-hmm. It is not a legal entity as such. That is it. For convenience sake in the House, these people have been grouped together and identified as the legislature party. That means a party whose wing is operating in the legislature. That is all. It is not a party as such. It has not been registered by the Election Commission or anything. It doesn't have such a legal standing, that it can independently take decisions so far as the party is concerned. The party has to take a decision. That decision has not been taken. He has not been authorized by the party to go and work out an arrangement with the BJP. So that problem is very much there. That way, he is not authorized to do this, and it is a totally unauthorized kind of action on the part of that chief minister. That is it. So naturally, it provides the ground for this Thackeray to move against them.
But the disqualification has to be decided by the new speaker.
No, that speaker, speaker has a problem there. That is what I was coming to. Now, what will the speaker do? In the House, after all, he has become the chief minister. It's a fait accompli. He has become the chief minister. Now, chief minister has a party. There is a party backing. Which party it is? It is Shiv Sena. So what will the speaker do? Speaker, of course, recognizing a party is not a function of the speaker. Recognizing a party is the function of the election commission. But so far as the House is concerned, each party gives a list of its office bearers to the speaker, and speaker goes by that. The legislative party leader, the whip, and other office bearers of the legislature party. That list is with the speaker. But that list shows that Uddhav Thackeray is the president of that party. And there are other people who are holding different positions in that party. Speaker has to go by that. But in this case, a speaker who is going to be elected will not go by this. It won't be a neat kind of operation. The speaker will say, I recognize them as the legislature party, and the rest of the things can be decided by the election commission. I have nothing to do with that. Let them decide. But for this House, I will recognize Mr. Shinde and the members who are supporting him as Shiv Sena, legislature party. If he says that, we can't do anything. That is the thing. He will say whether this faction is the real Shiv Sena or the other faction. That will be decided by that. So that's not my headache. That will be decided by the election commission. He can, wriggle out of that situation, perhaps in this manner. There is no other way possible, because as you know that this gentleman, this chief minister, he cannot take a plea that he is the real Shiv Sena, because that is not a plea which is allowed by the law, by the anti-defection law.
Okay.
You can't raise that plea. The only plea that you can raise is, we are 2/3. There is a merger between two parties. We are the 2/3 of the legislature party, and we agree with that merger, and therefore we may be exempted from disqualification. That is the only plea which is allowed. You cannot raise this plea that we are the real Shiv Sena, so we may not be disqualified. No, not at all. Because under the anti-defection law, under the 10th schedule, there is a specific mention about how your party affiliation will be determined.
Right. So the issues in Maharashtra are far from over. The legal and political issues will still.
It's only started.
Right, sir. So thank you so much, sir. Thank you so much for sharing your information about all these issues. It was a very enlightening discussion. Thank you so much, sir. Thank you.
Thank you. Okay.